And now we're going to move on to a couple of procedural cases. Now, the first case, I hope I've got the pronunciation correct, but I will generally call it KSM. KSM Henrik Zeeman SP ZO and HMRC. It is a Polish company, and the facts involved it contracting with another Polish company. It contracted for the installation of a boiler in the UK, and KSM tried to register for VAT in the UK, quite correctly in my view. HMRC refused to register based upon the answers of a questionnaire inherent in the application to register, by saying that KSM was making no taxable supplies in the UK. It later decided that KSM was making taxable supplies in the UK, and then assessed KSM for the VAT. And KSM said, this is not fair. We have a legitimate expectation not to pay VAT because you told us we're not making any UK taxable supplies. And therefore, we don't have to pay the tax under the assessment. There were two questions that had to be addressed by the upper tribunal by the time the case got that far. The first was, did KSM actually have a legitimate expectation not to pay the VAT? In other words, was there, what a public lawyer would say, a reason for HMRC to have to waive what the VAT that would otherwise be due? And secondly, if KSM did have a legitimate expectation, was it entitled to challenge the assessment which breached that legitimate expectation in the course of an appeal against the assessment, or is it obliged to go down the judicial review route? So if we take a step back, when we have decisions that are appealable decisions, whether it's a penalty has been issued, a discovery assessment has been issued, a closure notice has been issued, the Schedule 36 has been issued, all sorts of situations where one could find that you've got a decision made by HMRC which you don't like, your first port of call is to go to the first tier tribunal. However, there are many decisions that are made by HMRC that do not have an appealable right. For example, often in April, sometimes it comes out in May, individuals get a notice from the Revenue saying, we would like you to submit a tax return. So as a Section 8 notice, Section 8 of the TMA. If you get one of those notices, you can't appeal against the notice because there's no statutory right of appeal against such a notice. What you're supposed to do is comply with the notice. But if you've got an argument that the notice has been issued in breach of some public law duty by HMRC, what you could do is judicially review the Section 8 notice. Now, no one ever does, sledgehammer to crack a nut, but strictly speaking, that is an option available to you. Similarly, if you have a follow notice or an accelerated payment notice or one other of these decisions which HMRC can issue, which does not itself have a right of appeal, then if you wish to have these decisions struck down, quashed to use the terminology, then one option is to go to the High Court if you're in England and Wales, the Court of Session if you're in Scotland, the High Court of Northern Ireland if you're in Northern Ireland, on judicial review proceedings. The Revenue will say that is your only option. The Revenue will keep on saying that if you wish to raise a public law argument, you shouldn't go anywhere near the tribunal. You have to go on judicial review. And more often or not, the Revenue will point to the very strict time limits for judicial review and will point out that you are too late. And even when you're not too late, they'll still point out that you're too late. Now, until about 12 years ago, there was no real thought within the tax world that you could have judicial review kind of arguments, public law arguments, in the first tier tribunal, except in those handful of situations where the legislation itself gives the tribunal some form of quasi-judicial review challenge. For example, if you're looking at penalties and a special reduction, the first tier tribunal can substitute its own finding for special reduction on a penalty, but only if it has found a public law flaw, a judicial review kind of flaw to HMRC's own decision. In other words, that's an area where Parliament has actually carved out a small bit of judicial review and required those challenges to go to the first tier tribunal and not to trouble the High Court. But the Revenue will say that generally there is that clear divide: judicial review arguments in the High Court, appealable decisions in the first tier tribunal. However, in about 2009, Mr. Justice Sells, as he then was, now Lord Sells up in the Supreme Court, but he was in the High Court at the time, in a case called Oxfam, which was a VAT case, said, I'm not sure that it's true that public law arguments have to be taken to the High Court. I think, he said, that there's an argument that they should actually be heard as part of an assessment appeal. In other words, if you are challenging an assessment, so you have an appealable decision, the assessment, you can load on to that appeal any underlying public law challenges. Now, I think Lord Sells was completely right on that point. The Revenue really did not like it, as we'll see here in a moment. And that got the tribunals all excited for a few years, until a series of cases, Hock and Noor, went to the upper tribunal specifically with judicial review kind of challenges. So they started off in the first tier tribunal, which said, oh, well, following what Mr. Justice Sells has said, we have to accept jurisdiction. But the upper tribunal said, no, Mr. Justice Sells was wrong, and if you're wanting to run a public law argument, then except in those specific circumstances where public law rights have been carved out to the first tier tribunal, you have to go to the High Court. Now, things more or less rested there. But then about 3 or 4 years ago, a case called Burkitt came out, which said, it's not as simple as that. And where the question of public law is pertinent to the validity of the assessment itself, then actually there is no reason why you have to mount separate judicial review challenge. Now, the Revenue still doesn't like that, and whilst they're not going to say Burkitt was wrong, they'll just try to exclude it as much as possible. But we then had a situation in Beadle, which is a case involving accelerated payment notice, where the Court of Appeal said the following. Now, what was happened in Beadle was that Mr. Beadle could have JR'd the APN, actually it was a PPN, but it doesn't really make much difference. He didn't. But then when he didn't comply with the PPN in time, he got a penalty and then challenged the penalty through the penalty appeal. You know, the penalty is appealable in the first tier tribunal. Said, well, wait a minute, if the underlying notice is unlawful, then I don't have to comply with it. So I'm going to challenge the underlying APN through an appeal against the penalty. And what the Court of Appeal said, where a public body, here the Revenue, brings enforcement action against a person in a court or tribunal, including a court or tribunal whose only jurisdiction is statutory, so like the first tier tribunal, the promotion of the rule of law and fairness means, in general, a person may defend him or herself by challenging the validity of the enforcement decision or some antecedent decision on public law grounds. We'll continue the saving in a moment. But what Beadle was saying was the general rule would be, if you do not like the APN, then strictly speaking, the general rule would be you don't have to comply with it, and you can raise the challenge in the course of an appeal against the subsequent decision, the penalty. A good example would be a taxpayer who doesn't like the Section 8 notice. Obviously, you take the risk that you'll be liable for penalty, but strictly speaking, you can challenge the Section 8 notice itself in an appeal against the penalty issued for non-compliance with that notice. However, the scope for challenging alleged lawful conduct is reduced where it has been circumscribed by the relevant statutory scheme, which excludes such a challenge. And I believe that to be a completely correct principle of law. In other words, you don't have to keep going off to the High Court on judicial review grounds, but you can, in fact, challenge subsequent decisions in the course of the statutory appeal. But where Mr. Beadle lost was that the Court of Appeal considered that the APN legislation itself excluded such a challenge. Now, there was absolutely nothing in the APN legislation that justified such an outcome. However, the Court of Appeal took the view that, well, somehow the revenue didn't want these kinds of challenges, therefore it's implicit in the code. Now, I don't think that's good enough, but that's what the Court of Appeal said in Beadle, and the Supreme Court didn't take the case any further. But the general rule, Beadle represents the exception, but the general rule is set out in Beadle that you can run these arguments in the first tier tribunal. So applying what was said in Beadle, the upper tribunal said, it seems to us that a similar logic must apply. Even though technically the taxpayer is a claimant in the proceedings rather than a defendant, he is nevertheless defending part of an enforcement action by HMRC. The promotion of law, of the rule of law and fairness, means that the taxpayer should be entitled to defend himself by challenging the validity of the enforcement decision or some antecedent decision. In other words, in this case, the decision to assess on public law grounds, unless the entitlement is excluded by the statutory regime. That is a question of construing the relevant statutory language. So effectively, pretty much what Beadle had said, not surprising since this was just cited the Beadle decision. And in due course, the upper tribunal then went and said, here is an assessment. It has, you have the right of appeal against the assessment in the first tier tribunal. You are effectively responding to the assessment being equivalent to the enforcement action. It's the first step taken by HMRC to enforce what they consider to be a debt. Therefore, unless the statutory scheme somehow excludes such a challenge, and there was nothing in the VAT Act that excluded such a challenge, then there is nothing to stop such public law challenges, for example, a claim that there's been a breach of a legitimate expectation, to be run in the first tier tribunal, and this was an appeal from the first tier tribunal's decision. So what Zeman has done is to open again the question, can you run public law challenges to assessments in the first tier tribunal? And the answer is yes, if the statutory language does not exclude it. Now, the difficulty we have is that the Zeman case and the Oxfam case, also the Knorr case, all involve VAT. As far as I'm concerned, there's absolutely no reason why you cannot apply the same logic to direct tax. However, even if HMRC and the tribunals now form a firm view that the Oxfam approach applies to VAT, I suspect that revenue is going to try and cause a bit more trouble getting it extended to direct tax. But ultimately, there is no significant difference in the statutory language. There's nothing to say in the direct tax rules that such, or even to imply that public law challenges must be done on judicial review. And therefore you have the right, in my view, to raise such arguments for virtually all appeals where there is an underlying public law challenge as well. So Zeeman is going to be rather interesting seeing how that goes forward. But it's certainly consistent with the way the cases have been argued in the last few years, starting with Birkett, which was the first one to sort of water down what the Upper Tribunal had said in Hock and Knorr. Birkett giving a very clear principle, but now Zeeman taking it one stage further. So there'll still be some arguments in the next few years on this point, but I do believe that the direction of travel is clear. So Zeeman says, or the Upper Tribunal in Zeeman says, you can raise judicial review challenges. So then it had to deal with the second question: has there been a breach of the legitimate expectation? Well, on that point, the Upper Tribunal said there had not been a breach. It is true that the questionnaire was ambiguous. The taxpayer answered the questions honestly, but in one case mistakenly. One was based by an honest misreading of the question being asked. The other one was a mistaken view of the VAT status of its current customer, the other Polish company. So whilst one could have a bit of sympathy about the answers given to the questions, when HMRC responded to say, you are not making UK taxable supplies, it spelt out its reasons. It said you've confirmed that you are supplying construction services solely to business companies who belong in the UK and who are all registered for VAT in the UK. In other words, the reasons given by the revenue were ones which turned out to be incorrect. As the Upper Tribunal said, the letter contained a premise, a relevant qualification, and that relevant qualification was not satisfied. In other words, when you are told you are not liable to register for VAT, and in fact you cannot register for VAT because of X, when X is itself incorrect, you cannot claim a legitimate expectation when the revenue reasonably make that statement X on the basis of the information you have given them. So effectively, KSM Zeeman was given a warning: you do not have to register VAT because of X. X was not satisfied, and therefore Zeeman could not claim a legitimate expectation. It had an expectation, but it was not one which was legitimate. So from my perspective, it's a positive development of the law for the taxpayer itself, an unfortunate outcome because the facts were against it.